Hi guys, so this is going to be my third video about a proposed law from the Trudeau government that I am really worried about. I'm worried that it is a full assault on freedom of expression and speech. You can watch my other videos about this law, which I will link to in the description below. But this video is going to be about the criminalization of speech in Bill C-63 and why this proposal is so extreme. It even applies to speech that hasn't even happened yet. Crazy? I know. Before I get into it, I know that a lot of you, like me, are really worried about this bill. And that's why we at the Canadian Constitution Foundation created an online letter that you can send to your member of parliament telling them to stop and fix Bill C-63. Over 6,000 of you have already written to your member of parliament. And if you want to write about your concerns as well, you still can. You can go to the ccf.ca/fixc63, which I will also link to below. Now, let's get into this new plan to criminalize speech, including speech that hasn't even happened yet. If you're new here, welcome. My name is Christine, and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about interesting developments in constitutional law in Canada and about our ongoing cases. So if that sounds like something you'd be interested in, hit like and subscribe below. It really helps my videos out a lot with the algorithm. Also, please remember that nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. So those of you who are still maybe catching up on what's happening, this proposal was introduced in February of this year, 2024, and it is formally called the Online Harms Act. But it goes far beyond regulating online harm. And one thing it does, which is the focus of this particular video, is make three major amendments to the criminal code. The first amendment is to specifically define the word hatred in the criminal code, which currently doesn't have a definition. The amendment would define hatred as the emotion that involves detestation or vilification and that is stronger than disdain or dislike. This definition, which in my opinion is really just a number of synonyms for hatred, it comes from the case law, including a Supreme Court case called Whatcott. And the legislation specifically says that speech will not meet the criteria of hatred just because it discredits, humiliates, hurts, or offends. But given the subjectivity of the definition and the fact that it's defined basically in reference to itself by using a bunch of synonyms, I have my concerns. The second major amendment proposed to the criminal code in Bill C-63 is to broaden the current categories of hate crime offenses to capture any offense under any act of parliament that's motivated by hatred based on a prohibited ground of discrimination. This is what some people are describing as the standalone offense, an offense motivated by hatred. So currently, the hate crimes that already exist in the criminal code consist of prohibitions on willfully promoting or publicly inciting hatred. And there's actually pretty limited case law on incitement because the threshold for criminalizing speech is high. It should be high. This should be a high standard for a democracy to put someone in jail because of something that they said. But one of the concerns that I have about this new offense motivated by hatred proposal, and this isn't just my concern, a lot of scholars and practicing lawyers have the same concern. We're worried that this new provision would turn any federal offense, not even just those found in the criminal code, into a potential hate crime. So those who commit offenses could be potentially liable for life imprisonment. So what if you engage in mischief and the government wants to allege that it was mischief motivated by hatred? Or what if you engage in vandalism? And the government wants to argue it was vandalism motivated by hatred. That can exist as a major threat as part of the prosecution. It's a really radical proposal. Now, one of the people who has outlined some concerns about this is Professor Dwight Newman at the University of Saskatchewan School of Law. And he wrote about some of his concerns for the Fraser Institute. He wrote, I'm going to read you what he said. He said, consider a wayward 19-year-old painting graffiti who could be accused of being motivated by hatred. He could now be charged with an offense carrying the possibility of life imprisonment. That wayward youth needs corrective intervention, which might appropriately include criminal conviction for mischief, but a threat of life imprisonment is totally disproportionate to the offense. And Professor Newman writes that this could have a spillover effect. A major problem of establishing potentially vague offenses with vastly disproportionate punishments is that they can be used as a threat to elicit plea bargains from people who should not have to plead out. So the government has this huge potential to say, if you don't plead guilty, we could pursue life imprisonment for this otherwise possibly minor criminal code offense. So Professor Newman goes on to say, if anything in the circumstances of an offense could be used to suggest that the offender was motivated by hatred, the offender is now deeply vulnerable to new pressures to simply plead guilty of something in return for avoiding charges on the threatened indictable offense. This problem particularly affects people from marginalized communities. Some of the very people the government purports to defend will suffer direct harm from the existence of this misconceived offense motivated by hatred. Now, Professor Newman is not alone in his criticism. Canadian literary icon Margaret Atwood posted on X about the, quote, possibilities for revenge, false accusations, and thought crime stuff, which are so inviting. And she called it Trudeau's Orwellian online harms bill. And I think that she's absolutely right. But this is not where it ends. Those are just the first two amendments to the criminal code. The third major amendment is this restraint on future speech that I talked about in my introduction. So this amendment would allow individual Canadians, with the Attorney General's consent, so, your friends or neighbors or people who aren't your friends, your enemies and neighbors, it could allow them to seek peace bonds against others whom they fear will commit a hate crime in the future. So under this provision, provincial court judges would be empowered to call these parties to appear before them and determine whether there's, quote, reasonable grounds to fear that the defendant, the accused person, will commit such a offense. And when the judge ultimately decides that an individual is reasonably likely to commit a hate crime at some point in the future, their powers are incredibly far-reaching. Bill C-63 will allow a judge to issue peace bonds against individuals for up to 12 months that could require them to stop them from communicating with certain individuals or from consuming drugs and alcohol. It could place them under house arrest, or if the Attorney General is the one who has applied, it could require that they wear electronic monitoring devices like an ankle bracelet. So my friend Chris Kinsinger, who's a lawyer and scholar, and he's the director of the Runnymede Society, he has called this particular provision, the future speech provision, Bill C-63's most draconian provision. And I think that says a lot, given that the other provisions of the bill are also very draconian, like the possibility of life imprisonment and the return of a civil remedy for hate speech, which is what my last video was about. So Chris wrote in an article for The Hub that this part of the bill, the part that applies to future speech, is what is called a prior restraint on speech. So in short, a prior restraint is a limitation on expression that doesn't just target the harmful effects of that expression, but seeks to prevent such expression from taking place at all. And this is a departure from the many other ways our law frequently limits expression, like the laws around libel, defamation, sedition, and even the current prohibitions on willfully promoting or publicly inciting hatred. Those are all intended to punish expression and speech after it has already occurred. By necessity, prior restraints censor expressive content by turning agents of the state into the licensors of permissible expression. And indeed, in this case, it's not even the state itself, it's society at large. Anyone who is worried can seek a peace bond against another person who they fear will commit a hate crime in the future. The evidence that judges who are faced with this question will consider when deciding whether or not to issue one of these peace bonds will include the allegedly hateful content that the individual in question is expected to express. And it's by no means unreasonable to be worried that certain expressive content will be presumed to cause harm even where harm has not taken place, much less been proven on a balance of probabilities. The prior restraint issue is just one of the many problematic aspects of this proposed law, which, if passed, would be ripe for constitutional challenge. And that's a constitutional challenge that we at the CCF would really strongly consider bringing if the bill passes in its current form. But what do you think? What do you think is the biggest problem with this proposed law? Are you most worried about that squishy statutory definition of hatred? Are you most worried about the possibility of life imprisonment for crimes motivated by hatred? Or about the restraint on yet unspoken words? Or is there another part of the bill that concerns you most, like the amendments to the Canada Human Rights Act? Leave a comment below to let me know what you think the biggest problem is, and make sure that you write to your member of parliament as well to let him or her know. If you want to keep up to date about what is happening with this bill, you can subscribe to our email updates at the ccf.ca/freedom updates, or you can ring that notification bell icon, that little bell image right beside the subscribe button. If you ring that, you will get notified every time I have a new video out. And I'm going to be posting more videos about developments in this law, C-63, as it makes its way through Parliament. Okay, that's all for this video. Thanks for watching, and let's keep fighting for freedom in Canada.